Good evening, everyone. I'd like to call this meeting to order of the City of Morganton's Board of Land Use Adjustment. And with that, I would ask the members of this board if you have had an opportunity to review the minutes from our December 9, 2024 meeting, and if at the appropriate time, I'd be interested in entertaining a motion to have them approved.
I'll make that motion.
Motion's been made. Is there a second?
A second.
Motion's been made and seconded. All in favor of the approval of the minutes as written, please say aye.
Aye.
In the opinion of the chair, the ayes have it. The motion carries. The minutes are approved. I'd like to take a moment as the chair of this board to welcome a distinguished new member of our board tonight. Johnny Carswell is known to many of you in the community as a public servant for many, many years. He is an appointee of the county based on the extraterritorial jurisdiction slot that's available for this board, and has committed to continue his public service to this community. And we certainly want to welcome you tonight, Mr. Carswell.
Thank you, Mr. Chairman. Privileged to be here.
Well, thank you for that. Thank you for being here, and thank you for your service. Again, welcome everyone to this board and the matter which we have before it tonight. We are going to hear one case today. Case is case number 01-25, which is an application for variances from three portions of the City of Morganton's zoning ordinance. The application for variances shall be decided by a 4/5 vote of this board as set by our North Carolina law. And I want to take a moment in light of that to bring that particularly to the attention of the applicant tonight. And I do that because of the fact that we have one of the members of our board who's not present. And in light of that, if we move forward tonight, I want you to be very clear that therefore, given the statutory requirement of a 4/5 vote, that it would necessitate a unanimous decision amongst the four members of this body tonight. Your other alternative, of course, is to request a continuance until next month, at which time we would hope to have a full complement of our 5 board members. But please understand, we're constrained tonight. If we move forward, it's going to necessitate a unanimous decision. What's the pleasure of the applicant?
We'd like to move forward, please.
All right, thank you, sir. So, as I've already stated, tonight is an application for members of the public and the applicant for a request that a variance be applied by this board. And as I've already intimated, variances are set forth very clearly in our general statutes here in the state of North Carolina. And so with that, I'd like to just, for clarity and for the applicant's benefit, read specifically straight from the statute, which says that when unnecessary hardships would result from carrying out the strict letter of a zoning regulation, the Board of Adjustment, that's us, shall vary any of the provisions of the zoning regulation upon the showing of all of the following 4 elements, and they are these. Number 1, unnecessary hardship would result from the strict application of the regulation. And it is not necessary to demonstrate that, in the absence of the variance, no reasonable use can be made of the property. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. And then there's a reference to a Federal Fair Housing Act issue, which is not really relevant tonight, so I won't read it. But paragraph 3, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. And then number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulation such that public safety is secured and substantial justice is achieved. Before we begin, it's important for everyone to understand tonight some important facts related to this meeting. This Board of Adjustment meeting is known as a quasi-judicial proceeding, which means it functions much like a court proceeding in which one's individual rights are being determined. Testimony will be limited to only those issues concerning whether the application for these variances should be approved. The legal purpose of this quasi-judicial hearing is not to gather public opinions and suggestions as to the policy to be applied. The policy is already set in the ordinance. The board making the decision tonight must apply those existing policies to a specific application. The purpose of the evidentiary hearing tonight is to gather legally sufficient factual evidence to apply those standards which I've already read to the application based upon, and here's the standard, competent material and substantial evidence in the record. Are there any board members here tonight who feel that they cannot sit as an impartial decision maker in today's proceeding due to a conflict of interest? I'll start with you, Mr. Carswell.
No, sir.
How about you, Mr. Britton?
No, sir.
And to you, Mr. Lindsay?
No, sir.
And to the applicant, the chair will represent that I do not have a conflict either in the discretion of the chair. It's my opinion based on the feedback that we can proceed with no conflicts of interest. The order of business for this hearing will be for the case as follows. Firstly, the senior planner for the Morganton Development and Design Department will provide a sworn overview of the application. Board members will in turn be able to ask any questions of the senior planner that they deem appropriate. Secondly, then we will hear from the applicant, who will present evidence in support of the request and answer any questions from the board about the evidence presented. And then thirdly, if there's anybody else from the community that expresses the desire to either be a party or to be recognized to be able to give testimony tonight, we can deal with that. Is there anyone here tonight other than with the applicant or with the city's planning department who would like to testify tonight regarding this matter? If so, raise your right hand for the board at this time. It's in the board chair's opinion that he does not recognize any individual, and therefore will move forward accordingly. So any person or all persons who speak and participate tonight will be placed under oath. We have a Bible over here, and witnesses may also choose to affirm. If you'll just let me know ahead of time that you'd rather do that, I'd be appreciative. If you want the board to see any written evidence, such as reports and maps or exhibits, the witness who is most familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. In addition, in order for the testimony to be considered evidence, it can only be given by persons in attendance at the meeting. Otherwise, it's considered hearsay. And at this time, I would ask anyone who's wanting to give evidence to the board tonight to please stand and approach the podium up here to my right. where there's a Bible located, and if you would gather around that and place your left hand on the Bible and raise your right hand. And Madam Clerk, at this time, I will give the oath. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you very much. Y'all may be seated. I now open the public hearing regarding the application that's already been described, and I would ask at this time for testimony from the senior planner. If you'll please come forward, state your full name, your position with the City of Morganton, and we'll proceed accordingly.
My name is Wendy Smith. I'm actually the Director of Development and Design Services instead of the Senior Planner, or in the absence of a Senior Planner.
I'll change my script.
That's okay. Hopefully, we will have a Senior Planner by the next meeting. We'll see. And apologies, I need to log back on to the laptop. Okay. Ready?
Please proceed.
Okay. So just to give a summary of what we are talking about today, the site is a series of 4 parcels, adjoining parcels that border Rand Street and West Fleming Drive. The parcels are largely in zone EID with the corridor overlay, though the easternmost parcel is, that is the site of the current ABC store, is in zone HID, also with that corridor overlay. Through the middle of the site, as shown on the screen currently, are 2 adjacent Duke Power easements for high-voltage transmission lines that run through the site. And they are 68 feet wide each for a total of 136 feet wide. They are not allowed to construct any structures below those power lines. They can put parking, landscaping, those sorts of things, but no building structures underneath that. So there's a significant portion of the site that is hampered by not being able to build within that area. So the applicants have approached the city with an application to make 3 variances to the zoning ordinance in order to work around this hardship of not being able to place their newest proposed building structure, perhaps where it would be most convenient on the site, but underneath those high voltage transmission lines. So the first variance is a reduction of the front setback from 50 to 20. Because they are in zone EID, they have to have a 50-foot setback rather than a 20-foot setback. So the HID parcel gets a 20-foot setback, so everything else along that street would have a 20-foot setback, but since they're an industrial use in zone EID, they would typically have to have a 50-foot setback. So that's represented on the screen currently by the 2 blue lines. So 20-foot is the one on the left side of the screen, and 50-foot is the one on the right side of the screen. This is also taken from page 8, Appendix A, page 8, if you want to look at it in your packet that you have. Excuse me. The zoning ordinance presumes that in the corridor overlay, there will be additional design standards for buildings and for landscaping and for parking areas, because it is on one of our major corridors that are heavily trafficked areas, and they expect as people drive by, there's a certain view shed that you should see in that area. That's also why we have buildings set further back. So there are different design requirements, as I said, in that section. There are also different design requirements for industrial buildings than there are for other buildings in residential or commercial buildings in those areas, with, again, the expectation that your industrial buildings are going to be set further back from the road. So to bridge that difference in bringing the building closer to the road to work around the hardship of the power lines, there's a few items that we've detailed in your package that the applicants have proposed to address to move them towards what would typically be required of a commercial building in that area, of doing the vertical articulation, the projecting towers on the stairwells, the heavier building materials and darker colors on the lower portion of the building, varying that height of the building along the street frontage, the vertically oriented windows that they show examples of what that could look like later on in your package, the awnings for the horizontal articulation, again, the brick materials around that for materials and colors. So they've asked for the reduction, and they've said, here are some alternatives that we're proposing that would be typical of other buildings that, along that same stretch, would be expected to have if they were at that 20 feet mark. Do you want me to pause between each one and ask for questions, or do you want me to go through them all?
I think, why don't we pause there and see if we have any questions with regard, since they are three separate variance requests for purposes of the evidence presentation. Mr. Carswell, do you have any questions for the city representative with regard to the request for a variance regarding the setback restriction to 20 feet?
Not at this time, Mr. Chairman.
And to you, Mr. Britton, do you have any questions for the city?
No, not at this time.
And to you, Mr. Lindsay, with regard to the variance request to set back to 20 feet?
I do have one question, if it's appropriate. What I'm wondering is if the reduction of the setback will impose restrictions that would not have been there otherwise in terms of limiting how wide the sidewalk can be now or in the future, because, and I think it's directly relevant, but because, and that obviously is an area of great concern for pedestrian use at this point. That's one reason for asking that particular question, whether or not we will, by virtue of moving that setback and losing the parking lot that's there now, whether or not in a practical way, we will lose pedestrian options along West Fleming in that particular vicinity. That's question number one.
So, Chad, could you put my screen on?
It's very narrow at this point, and it's a narrow sidewalk, and it comes closer to the curb right now, but there is sufficient room, with the present setback so that you can make changes. I'm not sure with removing that setback that option doesn't, in a practical sense, go away.
So if, Chad, if you could show the screen now, if you can see where my cursor is moving there, that solid line, I believe, is the property line in there. The sidewalk is outside the property line already. It's in the DOT road reserve. The sidewalk is the minimum sidewalk that we would require in that area, and there are no plans and would not be a requirement to make it any bigger. It meets ADA requirements, and it would be preferably to stay within the DOT right-of-way rather than going into an internal property. At no point would I expect a sidewalk to be back 20 feet into a property, because then it becomes the appearance of private property there rather than a public sidewalk for people to walk along. So I can't see that we would ever put a sidewalk back in that area or would ever need to. It's sufficient the way it is, and there'd be no requirement to change it whatsoever as a result of this or any other matter that I can see. Further, Chad, if you show the other piece. So if you can see, the purple area is the area of the Case Farm site. Everything else along that whole section of West Fleming Drive in here is all EID already, or the SID state property, and those all have that 20-foot setback. That would be, the HID properties all have that 20-foot setback. That is what they are asking to come to. So it would be presenting a consistent frontage along there, so we shouldn't have a sidewalk jogging in and out.
So they're already providing as much.
They're actually providing double sidewalks, because they're providing a sidewalk on the DOT for the public, and then internal to their fence, they have their own separate private sidewalk that is also 5 feet wide for their employees behind their secure fencing. So they actually are already providing double the amount of sidewalk in that area, and it is my understanding that is not intended to change at all as part of this application.
Well, I wish that NCDOT would get to a different place and that the city would lobby with NCDOT to get to a different place, but that,
Well, Mr.
from your
Lindsay,
standpoint,
that's-
from your standpoint, that may be hypothetical, so.
I think it's outside the scope of this application.
Ms. Lindsay, any other questions for the city at this point?
I think there has been speculation that, further up the road, that there may be efforts to provide for a pedestrian bridge across the road. And
Mr. Lindsay, I'm gonna have to rule that out of order as not relevant to the purpose.
is raised and addressed as being out of order because I think it's important to address.
Ms. Lindsay, do you have any other questions for the city with regard to this application? With regard to the variance on the 20 feet?
Apparently not.
Okay. All right, sir. Then, in that case, Ms. Smith, if you will proceed to the second variance matter with regard to, what I believe that's the increasing the height up to 70 feet.
So for properties in zone EID, they're allowed to go to 65 feet. And the 65 feet line is represented by this dashed line across the middle here. And they're actually asking for just this critical processing air unit at the back to be able to go up to 70 feet to accommodate for this building. So not for the entirety of the structure, excuse me, but just for this portion at the back. Obviously, if you do the height limit, it's for the whole structure, but they're asking for that 5-foot reduction, which I think I figured up was about 7%, but don't quote me on that one.
Take your time. I work at a hospital.
Thank you. I was sick last week, so getting over that. So that's the sum total of that. This diagram shows the existing heights of other structures on the building as well as the proposed different heights of this building at the moment. Again, this isn't, you're not approving this design at the moment. You're approving the height to go from 65 to 70 feet for this structure. And if you wanted to be specific, for the critical processing air unit.
Anything else, Ms. Smith?
Not on the height.
So with that, we will take questions as we did on the last variance request, and I'll turn to you, Mr. Carswell, and see if you have any questions with regard to the change in height requirement for the city of Morganton.
Yes, ma'am. This is the only piece of equipment that can be used, the piece that has to be 5 feet higher that's been declared as critical.
I'm going to let you ask that question to the applicants when they
Thank you.
get up here, but thank you.
Any other questions for the city of Morganton, Mr. Carswell?
No, sir.
All right. And to you, Mr. Britton, any questions for the city of Morganton?
No, sir.
Then I'll turn to you, Mr. Lindsay, and ask if you have any questions for the city of Morganton with regard to the issue of the height requirement.
If it's pertinent, I'd like to ask, since we did address the quality of the facade, and it's obviously an attractive facade, I don't know if other things were considered for it, that presumably, the facade ameliorates any problems that might exist with respect to the height. In any case, if it were the case that the attractiveness of the facade made it acceptable to have more height, I'd like to ask whether or not there were any other, improvements to the facade, which is already attractive.
That's a great question. We had discussed that this would be screened. So rather than it just being a piece of mechanical equipment sitting there, again, if you were typically in that HID requirement, you'd have to have screening around that equipment to shield it from view. And they have proposed, that's what that screen is kind of showing. While we don't have the exact details of it, they had agreed that that would be a good thing.
I'm glad that question was allowable. It is an attractive facade.
Ms. Lindsay, do you have any other questions for the city with regard to the height issue?
I think that suffices.
And the chair doesn't have any questions, so we'll proceed on, Ms. Smith, to the last variance request.
Okay.
If you would
So
address
if you-
that for us.
again, look at the screen here. You'll see this building that you see here is the existing ABC store. Over here and zoom back in, and you can see that, sorry, I can't move this as easy as normal. You can see that it is in a different zone. It's in the yellow rather than the purple on the screen up there. The technical requirements of the zoning ordinance say that between zone EID and zone HID, you must have a 50-foot landscape buffer. That can be reduced to 37.5 feet with allowable reductions in the zoning ordinance. But what that would do for this site is put that landscaping buffer in the middle of their site, in the middle of the site for this development. So their desire, as you can see here, is to have a parking area that is connected rather than having 50 feet of landscaping through the middle of the parcel. So what they have proposed is to relocate that landscaping to the edge of their industrial use, because parking is allowed in zone HID, but to screen the entirety of their site instead of screen through the middle of the site and then have parking elsewhere and not be able to connect the two, et cetera. They have proposed a reduction in that amount of landscaping to the standard HID requirement in there that would be required between these two parcels, to create an opaque screen with a fence and 7.5 feet of landscaping there to screen it from what is the backside of the building with the Dollar General and Mighty Dollar, all the dollar stores. So they've proposed to, instead of doing this large bit of landscaping in the middle of the site, to do the fencing and the hatched area of landscaping on the edge of the parking area. And then along the back side of the building that is still within their site. Again, if I can flip over to this map that's screening the back side of their also industrial site, to put fencing along through there, and there is some existing landscaping in that area that might be enhanced. But it seems perhaps onerous to screen the site from itself.
Ms. Smith, is there any other testimony you'd like to proffer to this board with regard to this matter?
Let me go through there. No, I think that's fine unless you have questions.
So I'll turn to my colleague, Mr. Carswell, and ask if you have any questions for the city of Morganton with regard to the buffer issue.
No question, sir.
All right, and Mr. Britton, any questions regarding the buffer issue?
No, sir.
And to you, Mr. Lindsay, any questions for the city concerning the buffer issue?
I'm happy with the buffer.
All right, and so the chair has no questions with regard to the buffer issue either. Thank you, Ms. Smith.
Thank you.
And at this time, I would call up the applicant, William Pate, Case Farms. Sir, if you please come up to the podium there. And if you will kindly state your full name for the board, and if you will state your residency as well as your association with Case Farms.
Okay, thank you, guys. My name is William Pate, and I am the project manager for Case Farms, and I live at 5203 River Road here in Morganton.
All right, sir, thank you. And, sir, if you would proceed to share with the board the information you would like for us to consider tonight with regard to your application.
If it please, the right-of-way that Duke Power has on our property really restricts any opportunities we have to enhance our operation. And that's why we sought to move in the direction that we have.
Okay. Anything else you would like for us to know about?
Anything specific that I need to,
Well, then we can transition to questions if that would help you.
please, that would.
Yes, sir. So in that case, we'll move to you, Mr. Carswell. Do you have any questions for the applicant?
For one of the requests is to extend 5 feet up, and it says it's a critical piece of equipment. Just explain to the board why it is so critical and you need the 5 feet.
It will help and I'll let Joseph go in further detail, but it will help, it will allow us to turn the air over in the room, which is part of code.
And this is the only piece of equipment that will do that, correct?
Yes, I mean,
Thank you.
it's
And Mr. Carswell, do you have any other questions?
No
for
further
the-
question, Mr. Chairman.
All right. Mr. Breton, do you have any questions for the applicant?
No, sir.
Mr. Lindsay, what questions do you have for the applicant?
I'd like to know whether Duke Energy would consider having a different easement, given the substantial difficulties that imposes on you and on the city in terms of this request. I think that's pertinent because that, Duke, can move easements. And so at this point, since that's the proximal cause of the difficulties, I'd like to know, if this were Raleigh and money were not an object, whether or not Duke Energy would in fact move the easement for you.
I have not asked that specific question, but Duke Power has been involved in our discussions on what we could do and where we could build, and their right-of-way appears to be very critical to them to maintain their lines.
At that particular in their current particular configuration.
Yes, sir.
I accept that could well be what they have said to you without explanation. Thank you.
Ms. Lindsay, any other questions for the applicant?
That was a crucial one for me.
All right, thank you, sir. Mr. Pate, make sure I got you. Mr. Pate, with regard to the 20 feet setback issue, is it your concern that the 68-foot wide Duke Power easement containing high voltage power lines running through the middle of the site would result that there is an area of land 136 feet wide in width upon which no structures could be built? Is that correct?
Yes, sir.
And with regard to the front setback being changed from 50 feet to 20 feet, do you believe there would be any impact at all on pedestrian traffic out in front of the site?
No, sir. We don't foresee in increasing any of our traffic from this project.
All right, sir. With regard to the buffer issue, excuse me, going back to the the 20-foot setback change, you all have made a representation in your application that you're willing to make several changes to the location, including the proposed awnings over windows, the brick on the lower level, the kinds of things that you've set forth in your application. Tonight, would you be willing to move your application into evidence as a representation of the willingness that you all are willing to make conformity of the three variances that you've requested?
Yes, sir, I would.
All right. Any objection from the board to receiving the application into evidence based on the representations made by the applicant? The chair, hearing none, will accept this into evidence, your application and the representations you've made in the application. Given that, the chair has no further questions for the applicant. Would the applicant like to have any other witnesses present testimony on its behalf tonight? Sir, please come forward, and if you will kindly state your full name, your address, and then your relationship to the applicant.
My name is Joseph Asa Fullwood. I work with RFW Construction Group. We're helping Case Farms on this project. I live in 160 North Main in Dyer, Tennessee, so it's in West Tennessee.
Thank you, sir. Please feel free to move forward and share with the board any testimony you would like for us to receive tonight, and then we'll progress to ask you any questions that we believe we need to ask.
I was just gonna, Mr. Carswell's question about the critical processing area unit. Now, this expansion it's a breast packaging expansion. So they're packaging the raw food there, putting it in different packages, and then shipping it out at the dock. So typically in a food plant like this, you have a critical processing area unit. And inside this piece of equipment, there's filters and you know, it has a cleanup cycle, so when they do sanitation at the end, they can dry the room out afterwards. So it really is critical for food safety. And there are different manufacturers, but it's typical on a food production plant that you have a critical processing area unit.
All right, sir, thank you. Given your testimony, Mr. Carswell, do you have any questions you'd like to ask the witness?
I only have one, Mr. Chairman. Is this a fair representation of what the building will look like?
Yes.
And Mr. Britton, any questions for the witness? No. Mr. Lindsay, any questions for the witness?
No.
Sir, I just have one question for you. Given the fact that you've been heavily, it sounds like, involved in the project management, do you have any concerns with regard to any impact on pedestrian traffic out in front of the location?
No, sir.
Sir, I have no further questions for you. Thank you very much.
Thank you.
I would ask the applicant if you have any other witnesses you would like to address this board tonight before we deliberate. All right. Then in light of that, I would ask the board if you would consider a motion to approve all three variances en banc, or whether or not we need to move forward with each of them individually.
Mr. Chairman, I'd make a motion for all three.
So motion's been made that all three be considered en banc. Is there a second?
I'll second it.
Motion's made and seconded. All in favor, please say aye.
Aye.
And any opposed, like sign. In the discretion of the chair, the motion carries. In light of that, we will move forward with considering all three at one time, is what all that means. All right. And so at this time, I would ask if there's a motion to approve all three variances based on the criteria that was previously read tonight as set forth in our state statutes with regard to the approval of variances. Is there a motion?
Mr. Chairman, I'll make a motion.
Motion's been made. Is there a second?
I'd like to second that.
Motion's been made and seconded. Is there any discussion with regard to the approval of the variances that have been applied for tonight? In the opinion of the chair, there's no discussion. So before we vote, I'll read back over the what we're voting on tonight, which is the request for three variances to be approved with regard to the fact that the applicant has provided evidence of an unnecessary hardship involving a Duke Power easement that crosses the property line, that the hardship resulted from conditions that are peculiar to the property vis-a-vis the Duke Power line and its location, that the hardship is something that was not created by the applicant and that was not a result of actions taken by the applicant or the property owner, and that lastly, the requested variances are in fact consistent with the spirit, purpose, and intent of the regulation and zoning ordinance of the city of Morganton, such that public safety is secured and substantial justice is achieved. The motion's been made and seconded. The discussion of the variance request has been made. All in favor of that variance, those three variances being approved, please say aye.
Aye.
Opposed, like sign. The chair also votes aye. In the opinion of the chair, we have a unanimous decision of all four members of the board tonight, and consistent with state statute, you have a 4/5 vote of approval for the variances. Congratulations, your application is approved. Any other business for the board to be heard tonight in session on February the 10th, 2025? In the opinion of the chair, there is none, and therefore it's the chair's discretion to declare that this meeting is adjourned.